బ్రేకింగ్ న్యూస్ చూస్తున్నాం. బీసీ రిజర్వేషన్లకు సంబంధించి హైకోర్టులో వాదనలు ప్రారంభమయ్యాయి. అయితే బీసీలకు అనుకూలంగా తీర్పు వస్తుందా, ప్రభుత్వానికి అనుకూలంగా తీర్పు వస్తుందా లేదా అనే దాని మీద అయితే ఉత్కంఠ నెలకొంది. అందరి చూపులు ఇప్పుడు హైకోర్టు వాదనల వైపే ఉన్నాయి. అయితే బీసీలకు రిజర్వేషన్లకు సంబంధించి బిల్లు ఆమోదించారా అని న్యాయస్థానం అడిగిన ప్రశ్నకు అడ్వకేట్ జనరల్ సమాధానం ఇచ్చారు. అయితే గవర్నర్ దగ్గర పెండింగ్ లో ఉంది అని ఆయన సమాధానం ఇచ్చినట్లుగా తెలుస్తోంది. రిజర్వేషన్లు 50% మించితే ఎన్నికలు రద్దవుతాయనే నిబంధన ఉంది అని పిటిషనర్ల తరఫున న్యాయవాదులు వాదిస్తున్నారు. మొత్తానికైతే వాదనలు అయితే కొనసాగుతున్నాయి. ఇప్పుడు హైకోర్టులో జరుగుతున్న వాదనలు లైవ్ లో చూద్దాం.
The rest of the seats must be as for the general category. So today also we are not asking for the stay of the election process. We are only saying that let the elections be conducted in accordance with the law passed by the state legislature. Para 14 it was urged that population of OBC in some of the local bodies is more than 50%, and for that reason percentage indicated in the report submitted by the commission is a conservative approach and needs to be taken forward. That cannot be the basis to disregard the constitutional mandate and need to observe the triple test procedure indicated by this court. The political parties who claim to be the protagonist of participation of OBC in the governance of local bodies are free to nominate candidates belonging to the OBC category in the constituencies concerned, and even against all the general seats available for reservation of scheduled castes and scheduled tribes. We do not wish to dilate on this on any consideration. The operative portion Madhya Pradesh came in para 27, 189. Now, just to conclude on this, page 189, only two paragraphs. 189, the same, you cannot conduct elections unless para 27. Lots of you may just make a note of that. That para 27, they say that you can't hold elections unless you comply with the triple test. And what is important, because in para 31, they say the directions we have given is not just for Maharashtra and Madhya Pradesh. It's for all states and election commissions throughout India. So, this is critical, Not only we now have Krishnamurthy and Vikas Gawali, but a Supreme Court order giving a direction under Article 141 that you cannot hold elections if you do not comply with the triple test. Para 31, I'm sorry. And 31. We once again make it clear that if the delimitation is not done by the state government in terms of the Amendment Act, or the triple test is completed in all respects for providing reservations so and so, the state election shall give effect to this order in respect to so and so which have become due. We also make it clear in this order that directions given are not limited to Madhya Pradesh State Election Commission, State of Madhya Pradesh, Maharashtra State Election Commission, but to all states, union territories, and the respective election commission to abide by the same without fail to uphold the constitution. So the direction now given, all states it has been given, and I'll conclude by showing Malad that the final interim order, page 171. Page 174. Maharashtra went ahead and notified the elections. The Supreme Court said that since you have not complied with the triple test, you cannot proceed further. 174. When the matter came up, this is the Lordship's query. This came from the High Court. On the issue of interim, the High Court, Bombay High Court refused to grant interim relief. matter went up to the Supreme Court. When the matter, on the issue of interim relief only, when the matter came up before this court on 6/12/2021, it was directed that the Maharashtra State Election Commission shall not proceed with the election program as already notified, providing reservations for as a triple test compliance required under decision of 3-judge bench in this court was not done. Not the Supreme Court intervened, and then the operative directions was given for again for all states and page 178. The last paragraph, we reiterate that similar dispensation be followed, including the compliance of triple test by all states or union territories if they intend to conduct election of local government and provide for reservation for the OBC category. In case the state or the this is to what direction? In case the state or the union territory is not in a position to fulfill the triple test requirement, and the election to any of its local bodies cannot be postponed beyond the statutory period, the concerned state election commission ought to notify the proportionate seats as open category seats and proceed with the election of the local bodies. On page 180, my lord.
These matters are pending for final.
But these are interim orders. So, my lord, on page 180 also, they said any election program already notified also has to comply with the triple test. So just to conclude, Manoj, my submissions are number one. My submission number one, that the legislative pedigree has not been satisfied. Two, the constitutional requirement of 285A has not, sorry, the statutory requirement of 285A has not been satisfied. Three, the triple test in Krishnamurthy and Gawali has not been satisfied. And four, para 13, it must be local body specific and it cannot be done. There's a final contention, my lord, which our own High Court has said, you anyway cannot do any reservation on the basis of unpublished data. That my friend will show. But this is my focus. I'm grateful for your patience.
Yes. Yes, I'm appearing in item number 24 and 42, my lords. Lordship may kindly see.
You can give a small sheet, type all these 4 propositions. Not in detail, because
No,
detail.
one page, madam. One page.
That's similar to what my friend argued, but a little more dilation, my lords. Kindly see, my lords, my argument primarily is, my lords, there are actually 2 laws. The learned AG on 27th argued on legislative competence, and I seek to take issue with that. My lords, when there are 2 laws, the law declared by the Supreme Court is law, and I would say stands on a higher pedestal than statutory law. So, my lords, there are 2 laws. One is the law declared by the Constitution Bench of the Honorable Supreme Court in Krishnamurthy with regard to local body election. But, my lord, they have taken inspiration from Indra Swani and have held, my lords, 15.4, 16.4. The benchmarks on which you identify persons for 15.4, 16.4 may be different, as opposed to political representation in local body election, how you identify BCs and all. Those may be different. But, and this is only relevant for your lordship, my lord, insofar as the cap of 50% is concerned, the cap of 50% will apply to 15.4, 16.4 as also the local body election articles.
This is what he has argued.
Yes. So therefore my contention, my lords, is the law says, the law as held by